Hello, everyone. Thank you for joining us tonight as we share important information about Palestinian immigration updates. Before we begin, I'd like to turn it over to our interpretation staff.
مرحبا جميعا، اسمي نور وأنا مع المركز العربي، واليوم راح أكون بترجم للجالية العربية.
السلام عليكم جميعا. أنا اسمي طارق وحكون المترجم اليوم كمان. إذا أنتم بدكم تسمعوا الترجمة باللغة العربية، الرجاء الذهاب إلى إذا كنتم على الهاتف الذهاب إلى أسفل الشاشة آخر شيء على اليمين 3 نقاط أو مور، وثم اختيار اللغة العربية. إذا كنتم على الكمبيوتر اختاروا أيقونة الكرة الأرضية ومن ثم اختاروا اللغة العربية. لنتأكد إنه في ناس بدها لغة عربية، ممكن ترفعوا ايدكم او تكتبوا شيء بالشات انه انتم بحاجه ترجمه عربيه. اذا ما في محتاجين عشان ما نحن ما نترجم.
Thank you, Noor and Tarek, for that. And thank you all again for joining us today as we share important immigration updates. To provide some background about Project IJP, or Project Immigration Justice for Palestinians, was formed out of a national collaboration of attorneys who responded to the need of Palestinian immigration. We have been able to, since our formation, provide legal services to over 150 families who have reached out to attorneys and have been connected to attorneys to help them with family reunification cases and explore their humanitarian immigration options. In addition to providing direct legal services, Project IJP, alongside other national organizations, has advocated for a more comprehensive humanitarian approach to Palestinian immigration as a result of the ongoing genocide that is now entering its 4th month. Since we last spoke during our previous community forum, there have been some changes in how the administration treats Palestinian immigration cases. It now accepts requests to expedite family reunification cases and also accepts online applications at the U.S. Embassy in Cairo, assuming that both the petitioner and the beneficiary are in Egypt at the time of application. Since we also last spoke, the task force, which was responsible for adding names to the crossing list, has been dismantled. And instead, families are asked to add names to an email and send that to the U.S. Embassy in Jerusalem, which is collecting the names and adding it to a crossing list. We continue to demand that all family members requested to be added to the crossing list are in fact added, and that the U.S. fulfill its obligations to U.S. citizens and their families here and abroad to keep them safe and to protect them. Recently, on February 14th, President Biden issued a memo that directed deferred enforced departure for Palestinians. With us today is Hassan Shamia, a Palestinian-American immigration attorney who will share more information about deferred enforced departure, or DED for short. Please, Hassan, go ahead.
Thank you, Amriya. Assalamu alaikum. Before I start talking about DED, I just want to be sure that people understand what this forum is for. I see a couple questions that are geared towards things not related to DED and general green card questions. This isn't the forum to get those questions answered. This is specifically for immigration issues related to the ongoing genocide in Gaza. As Amriya mentioned, on February 14th, 6 days ago, President Biden designated that Palestinians would be eligible for something called deferred enforced departures, or DED. What DED is simply protection from deportation, meaning if you were in immigration court and facing deportation, you cannot be deported to Palestine under these new guidelines set by the president. It also allows people who qualify for DED to obtain a work permit. Now, in our meeting with immigration officials, we were able to get some commonly asked questions answered. Now, the first question is there an application for DED? How can I apply? There is no application. Everybody who is eligible is automatically covered by this program. If you want a work permit, then you need to apply for that, and that will be covered by another speaker further on. Another thing to note that is very important, anybody who's Palestinian who was in the United States February 14th and before is eligible. If somebody entered after February 14th and is Palestinian, they are not eligible for the DED program. And DED does not provide status. It simply provides relief from deportation. Even though you're eligible for a work permit, it doesn't give you status per se. So you cannot adjust your status to something else. We all saw that when the Ukraine war broke out, that immigration officials launched programs for Ukrainians to enter. And we haven't seen a program for Palestinians yet. And immigration is saying that they're looking into everything, but this deferred enforced departures program is the first step. Now, to be clear, this program is for people already in the United States, not for people who are abroad. There are questions surrounding working with a work permit through the DED program while on an F1 status, because the memo by the president last week indicates and has some discussion towards that. And a speaker later on will address that in a little more detail. Now, this DED designation was for a period of 18 months, but the president has the sole right. He is the only person who can decide whether or not to extend DED an extended period of time. Now, currently, there are two other countries that are covered under DED. Liberia, which was first designated in 2007, and it's been extended up until June of 2024. That's 17 years. And Hong Kong, which has been valid for a period of 3 years. I say this to let you know that even though the memo said DED is valid for 18 months, there is a chance that it could be extended beyond. And I want to be sure people understand that DED is not like TPS. TPS is temporary protected status. TPS is a status. And if somebody has TPS and their asylum application is denied by the asylum office, then their case is not sent to court. But even if you are Palestinian and you are applying for asylum with the asylum office and your application is denied by the asylum office, your case will be referred to court. So again, deferred enforced departures, DED, is not technically a status. It is just protection to prevent you from being deported to Palestine, and gives you the right to get a work permit. And there's also discussions of potentially getting a travel document to be able to travel out of the United States and come back in while under the DED program. Of course, we don't necessarily recommend that this tool be used for everybody. And we recommend that you seriously discuss with an immigration attorney should you decide to travel on a DED program if that travel document becomes applicable for Palestinians. Because there are risks that everyone takes if you travel outside the United States under this program. I look forward to answering any questions you may have at the latter half of the program. Thank you.
Thank you, Hassan, for that overview. We'll now turn to Lina Barudi, who will discuss immigration court and deportation and asylum implications of DED. Lina?
Hi, everyone. Good evening. I just want to start with a brief overview of, and a very simple version of the requirements for asylum. One is that you have to be physically present in the US or at a port of entry. Two is that you must have suffered past persecution or have a fear that you will be persecuted in the future based on a reason protected by the US government, such as your religion, ethnicity, political opinion, gender, or sexuality, or another thing. You have to file within 1 year of your most recent arrival to the United States, unless you meet one of the exceptions for a late filed application. Once you have an application for asylum on file, you really can't be removed from the United States. But if your application is not approved and you don't appeal, then you're subject to removal. Here's where DED comes in. DED, as Hassan said, it's not a legal status, but it's basically a period of authorized stay, which means that certain Palestinians cannot be removed from the US during the DED period. DED is going to be helpful for individuals who are facing deportation from the United States, people who have filed and lost all of their appeals, people who are detained because their removal cases are expedited, and people who need a work permit and may not qualify under another category. For example, your clock is stopped at less than 180 days. People who have active removal proceedings in court may be able to request to close their case during the DED period. And this could be really important for individuals who might be seeking an alternative form of relief, such as through a marriage petition, and you're waiting for the I-130 to be adjudicated. You might be able to ask the judge to admin close your case. People who are covered by DED may also be able to move to dismiss the removal proceedings altogether so they can file for asylum with the asylum office. And whether or not you want to do that is a strategical decision that you need to discuss with an attorney. And if a Palestinian is in immigration detention right now, depending on the reason for detention, I would certainly argue for their release based on the DED announcement, because there's no foreseeable likelihood of deportation, at least for the next 18 months and maybe longer. One important thing to keep in mind for DED is that it doesn't cover certain individuals, even if they're Palestinian, including people who have certain types of criminal convictions, people who the US government believe pose a danger to the public safety of the US, people who are barred from asylum. And this includes people who were firmly resettled in another country, meaning they had legal status in another country prior to coming to the US, or if the government believes that the person engaged in terrorist activities. This last point is really important here because engaged in terrorist activities is very broad under immigration law and includes people who assisted or gave any type of support to any group that the US government believes is a terrorist organization, even if it was done under duress or under threat of harm. I think the big takeaway here is that asylum law and removal defense is very complicated. It's an area of law that is constantly changing. So don't rely on information in Facebook groups or public information. It's essential that you talk to an attorney to represent you and guide you through your case. Thank you.
Thank you, Lina, for sharing all of that. We'll now turn to Amanda Gennerman, who will provide more information about how to apply for work permits, EADs, and what does it mean for students who are here from Palestine.
Thank you, Amraya, and thank you to my colleagues for being present this evening. So the work permit process, this is something that is accessible through a USCIS website. And on the USCIS website, the form that is required to obtain work authorization is the form I-765. And again, this is a free form. I say that because I also have individuals who go to websites and pay for these forms. That's not what you need to do. There is a filing fee, but to access the form, you should be utilizing the uscis.gov website. One thing, if you do visit the USCIS website right now, in the banner of this website, it will indicate that DED has been designated for Palestinians. There's not a lot more information on that. And so as we are talking about, as time tells, or as a federal register is made available, we will have greater details. So again, as my two colleagues prior to me have indicated, please seek legal counsel. Seek it through private bar attorneys, trusted governmental, non-governmental organizations to get your questions answered. The last thing we want for anybody is to be put in harm's way for an application or a benefit you may not qualify for. So that being said, the I-765 form is several pages. It is mostly biographic in nature. Part of the requirements to fulfill the I-765 is to apply with a filing fee, which currently up through April 1st will be $410. After that, a new filing fee structure is put into place. So as that gets closer, again, you'd want to refer either to the USCIS website or speak with counsel on the change in fees. In addition to the filing fee, 2 passport-style photos have to be submitted with this application. And again, the information that you are providing in this application is now continuing to build on either a course of action you have taken prior with the Immigration Services, or this may be your first time submitting any information to USCIS or the Department of Homeland Security. So it's really important that the information that is being put on this application is accurate and consistent with prior applications. Okay, again, we want to make sure that people who are applying for benefits are doing so appropriately. Once the application is put together and submitted to the government, a receipt will be issued saying, thank you for your money, or your fee waiver has been granted. And from there will be a request for you to appear for a biometrics appointment. And what that is a fingerprint and photograph appointment at a local USCIS ACS office. And again, those are the instructions that will be sent to you at your home address. From there, we are hoping that work permits would be issued possibly within 3 or 4 months from the time in which you apply. Now, during that period, if you do not have authorization to work under some other category, you are not allowed to work. You have to have this work permit in hand to be able to apply or to continue working with authorization. In addition, on the I-765 application for employment authorization, there's an opportunity to select that you would like a Social Security number. Again, we know that certain Palestinians are present in the United States under different status, and they may already, or you may already have a Social Security number. There is no reason to get a new Social Security card under this program. So again, if you already have that benefit or that designated number, that is something that does not have to be repeated at this point. But if this is your first time applying for a work permit, then yes, you would want to select the box for a Social Security number to be issued to you upon approval of this document. And again, from there, as we have been made aware, this program is currently an 18-month program. So if the application is filed come the beginning of March and it takes 3 months, it would likely be authorized through the designation of 18 months from the February 14th announcement. So you may not get a full 18 months of authorized employment, but it will be valid through that date of 18 months from February. Now, one of the things that Kassan mentioned is that the president does have authority to redesignate or to extend this program. So should 18 months come upon us and the crisis remain as it is, heaven help us, that this program would be allowed continued protection. Under that circumstance, you would need to, again, discuss with an immigration attorney or, again, a selective agency that you trust on whether or not it would be the proper time to renew your work authorization. But we do know that you could be eligible for that if the program continues. And that would be the same situation for these travel authorization documents should they become available under these circumstances. So that's the general overview of the employment authorization application. Again, uscis.gov is, again, the location in which you would find that application online. When we talk about F1 students and the different aspects of possibly being here as a J1 or an F1, we know that certain designations of non-immigrant visas have limited authorization to work. With the DED program, this expands those opportunities or should expand those opportunities. And what Ghassan had referred to is that in the presidential designation, there was language specific that says that the government can consider suspending regulatory requirements with respect to F1 non-immigrant students who are Palestinian. The idea of should consider or consider suspending does not mean automatic and is not the same as the term shall. So if you are an F1 student, or if you are a J1 student, or if you do hold some other non-immigrant status, we really do encourage you to speak with a legal representative to determine whether or not getting an EAD or a work permit under the DED program would in any way jeopardize your current non-immigrant status. But it is possible, what we want you to hear is that you can be here as an F1 student right now and have this blanket layering of protection of DED. Because again, that is not something you have to apply for. You just would have to be able to identify that you qualify for this benefit or this form of deferred departure under the circumstances and under the law that it is announced through. So again, what we just continue to say every time somebody speaks, talk to somebody that you trust, speak to a legal representative. It really does matter because once you're in the immigration system, that process follows you regardless if you are now applying based on a marriage application or an asylum application or trying to move into some other sort of classification. Your file only gets bigger with immigration. So please know that all the information you put in on any application should be accurate and consistent. And again, to always seek counsel with any questions that you may have. So thank you.
Thank you for that, Amanda. That was a lot of information. If you all have questions, we are collecting those questions so that there will be a long Q&A period to answer hopefully everyone's questions. And that was a lot of information. And just a reminder that this presentation is for informational purposes only. We do recommend that you speak to an immigration attorney, either through Project IJP or an attorney of your choosing, to understand what applies to your specific case. Next, we have Attorney Ban Alwardi, who will be talking about statelessness and how it applies to Palestinians. Ban?
Thank you, Amriya. My name is Ban Alwardi. I'm an immigration attorney with the IJP and also practicing in Los Angeles, California. Another area that has been emerging lately, an area in the law, is considering supporting legal status or a categorization of benefit called statelessness. In August of 2023, the USCIS released a guidance memo to address people who are considered stateless individuals who are currently inside the United States. The guidance in the memo went into effect on October 30 of 2023. And this memo basically clarifies that a person's status as a stateless person can become an important factor in applications for immigration relief. like asylum, potentially waiver applications, or any other form of immigration benefit that requires discretionary analysis or very fact-specific review. What we do know, since this is such a new guidance, we do know that this guidance does not create a new immigration status. It does not create a new immigration form of relief. We do know that the statelessness guidance is applicable to people who are currently in the United States. We also know that the memo is providing for USCIS officers to be trained on making determinations if a person is stateless or not, and whether this is relevant to an application that is filed. We do know also that statelessness can be used as a positive factor when reviewing various discretionary applications for relief, like asylum. But because it is so new, there are many questions that remain that we need to kind of practice and see with our cases where it's going to be applied, but in a helpful way for our clients. The USCIS currently estimates that there are around 220,000 individuals who could be considered stateless in the United States right now. Palestinians have been documented to be the largest stateless community in the world, and this fact has shaped the lives of generations of Palestinian refugees since 1948. The guidance that the USCIS has issued specifically states that the Universal Declaration of Human Rights says that everyone has a human right to a nationality. When you have a nationality, you may have the right to education, the right to work, the right for medical care, the right to travel, the right to own property, to be protected by the laws of your nation. But if you are stateless, you don't have those rights. And so it's very important to understand that if you, for example, have an asylum claim and you assert that you are stateless as a Palestinian applying for asylum, you can argue that your human rights have been violated and that as a stateless person, you have been persecuted. This could be one of many reasons why you might assert asylum protection in your application. We are looking into how this could apply in requests to expedite cases as well. As we know, the statelessness has been a problem for generations, as I just said. But now more than ever, there are really urgent reasons to apply for expedited treatment of cases, including the ongoing genocide that we are witnessing now. Where this might also be relevant is in waiver applications, where a very fact-specific review is made of cases for hardship and other factors that are discretionary for officers to make. Statelessness can be something that you assert to compel an officer to approve your case as well. Where we are also seeing where this might help cases is in a form of like a layer of protection similar to the DED program that my colleagues have described, which includes deferred action. It's another layered form of protection. It's not its own benefit, but it could help establish a reason why you should not be removed from the United States. If you are in removal proceedings and hopefully you have an immigration attorney assisting you, you should inquire with your attorney about how your status as a stateless individual may help either dismiss your case, terminate your case, or qualify you for additional review based on those facts and what kind of persecution you've suffered. Deferred action status can also lead to employment authorization, so for a work permit. Another area where we're seeing this may be applied is potentially in a program called Parole in Place. And this is a very specific program that is normally historically applied towards family members of people who are serving in the US military. But interestingly, if you can establish that you are physically present in the United States and also entered the US without a visa, so unlawfully entering the United States or without inspection, you could potentially use this stateless categorization to grant you protection from removal for a period of 1 year. This is a very specific form of relief and really requires analysis based on your facts and your history, and it's really advisable to speak to your immigration attorney about it. Currently, we are understanding that this memo went into effect on October 30 of 2023, so just a few months ago. But there is discussion on how this determination can be applied retroactively. So how can somebody's claim as a stateless individual go backwards and apply to cases that have already been filed? We are also interested and will be working on advocacy around how this can help cases for humanitarian parole. It is not clear at this point. Everything is very new, but it is an interesting area to examine with your immigration attorney. It is very important, again, to speak to an immigration attorney before making claims that you are stateless. It's a very fact-specific analysis. You might have issues because you may have travel documents or the right to live in a third country that could impact this determination as well. So this is very important to speak to an immigration attorney about, but it is something definitely to keep in mind when applying for immigration relief. Thank you.
Thank you, Van, for sharing all of that. We can turn now to questions and answers. And the first question we have is, would I be eligible for DED if I'm on a tourist visa and I came before February 14, 2024?
And I think the answer is, so long as you meet the other criteria that Lena had spelt out, the answer would be yes. And that includes not being considered a safety threat to the United States, amongst the others. But assuming that you meet all those other criteria, yes, you should be covered.
Okay, so here's a follow-up. I am an overstay B2 visa from 2012, and I have reason to seek asylum, or new reason to seek asylum, and was going to last month, but now this DED came out. What should I do?
I can also answer that unless somebody else wants to chime in. As we mentioned, DED does not require you to file an application. If you meet the criteria, you are automatically protected under the DED program. And so if you meet the eligibility requirements for asylum that Lena had spelled out, and you consult with an attorney, especially as you've been in the United States for over 12 years, you can theoretically file for asylum and be protected under DED at the same time. But again, no application for DED is required.
Okay. So is DED, is someone eligible for DED if they are Palestinian with a Jordanian passport?
So I can talk briefly to that. My short answer is yes. The long answer is, again, we want to have greater clarification in the Federal Register. And when the group of us, and all of us were fortunate enough to be in the White House briefing on this matter, this specific issue came up because we do know that there are individuals who are Palestinian ethnically and have documents from other countries. And so the government's response to this was, in a sense, it's a broad opportunity for individuals who identify and have some or an opportunity to show that they are Palestinian, even if their travel documents or other items may say other countries. And I'm going to open that to our panel in case that was a misunderstanding, but I believe that that is what was taken away from that meeting.
Yes, that's correct. That's what they said. I think we're not going to know the specifics until the Federal Register is published. We pointed out to them that there are many Palestinians who are here from Jordan, Syria, Lebanon, and we asked about how those people will be treated and whether they will be covered by DED. And they suggested that the answer is yes, but it's hard to say definitively until we see the actual Federal Register.
If I can also just add to this point, for a person who has a Jordanian passport, it would be very important to also gather any documents that you have for yourself or from family to establish that you are Palestinian. And that is interesting because the statelessness guidance also allows for secondary evidence. So if you don't necessarily have access to documents because they were either destroyed or abandoned, in an emergency situation, you could also use secondary evidence like a description in a detailed declaration about how you know you're Palestinian, and assert that you are stateless. And so that extra flexibility should be applied in reviewing your case.
And I just wanted to add that I know it's frustrating for people when you ask a lawyer a question and you don't get a yes or no answer. And the reason why is because, as everybody's mentioned, things change so quickly, so rapidly. Rules are clarified. I mean, the White House made this announcement without the register. And the register is really the document that's going to enable us to answer a lot of these questions with absolute certainty. So we're giving you answers based on the best information that we have now. But again, immigration changes rather quickly.
Thank you for that. And the next question, where can I find the application for DED and how much does it cost to file DED?
No application for DED. I'll say it in Arabic, fish talab la DED, okay? It's free of charge. There's no application. The only application related to DED is the work permit you can get from DED protection. But to get DED itself, no application. You are automatically covered by it if you meet the criteria.
So can I apply for employment authorization right now, today?
I would say no. Lena, were you going to say yes? No, I would say no.
I think yeah. Go ahead. Go ahead, Mandy.
And the only reason I say that is, again, when I go to the USCIS website today, it has very clearly DED covered countries, and it has Liberia and Hong Kong, and it explains exactly what the steps are and identifies the Federal Register notice citation. That has not been uploaded yet to the USCIS website. So I would say you take risk in submitting an application to a place that doesn't maybe know what to do with it at this point. They could take your money, it could get lost, and you could be very frustrated by the circumstance. It could be rejected. So we realize this pause is a pause you may not want to take, but it is something that, it would be kind of that stay tuned, check daily on the USCIS website. And again, between an immigration attorney and the USCIS website, that's really where you should be obtaining that general information. And again, as colleagues have said, not through the other Facebook and Google groups, just because there's just a lot of misinformation out there, and that never serves us.
In that case, how does someone apply for employment authorization once that's open to them as an option?
I can address that. So again, on the current website, uscis.gov, and Maria, I'm not sure if there's a way to put that in a chat, if there's a function, and again, I'm saying it, I'm trying to be as slow as possible, uscis.gov. That is the United States Citizenship and Immigration Services website. In that large platform, there's a search button, and or there's a tab for forms. And so again, the form that we are referencing today is the form I-765, Employment Authorization Document. By clicking on that document, there are additional opportunities to download the application along with instructions. And then generally there's an area to say, where do I file this application? So it is user-friendly. It can feel overwhelming. Sometimes even I have to go back on a daily basis to check where I'm filing things because they change where you can file applications. And the other piece is the versions. So these applications, the form itself sometimes changes. And again, that's why I would not say don't file this or prep it now. Wait until we have given the clear announcement that they are accepting these applications. And at that point, that's where you want to make sure all of your information is accurate and you're using the most up-to-date version. But again, that information can be found at uscis.gov.
I do want to follow up with Amanda's point about not filing until the Federal Register comes out, because we don't know what the filing address is going to be. And also, when they released the DED announcement for Hong Kong, they listed the various types of passports and travel documents that you can use to prove that you're originally from Hong Kong. So I'm not sure filing before the Federal Register would be a good idea, because I'm not confident that the USCIS workers would understand, for example, the various Jordanian passports that Palestinians hold. So I think just wait. When the Federal Register comes out, let's see what it says. Let's see if they properly explain the various travel documents and passports, and then go from there.
Thank you for that. So the next question is whether I can ask the court to close my case if I'm Palestinian because of DED.
You could ask the court to close your case for any reason. I mean, whether or not the court is going to do it, it's really going to be a case-by-case basis. There's various things that you can do in court. You can administratively close your case, admin closure, which basically means you're just closing the file and putting it on a shelf. Or you can ask for dismissal of the case, which completely gets rid of your case from court. You may or may not want to do that, depending on the particular circumstances of your case. So you really need to talk to an attorney about your specific case and then decide. And in the end, you can always ask the court to do whatever you'd like. Whether or not it's going to happen is going to depend on your circumstances. It's going to depend on the judge. It depends on the government attorney.
And with our meeting with immigration officials, they stated that there is no blanket rule across all of these courts, and that each court has what they call discretion, or the ability to decide for themselves whether they will close your case based on DED or not. So if you hear about a story about your cousin's friend's uncle who got their case closed from DED, doesn't necessarily mean your case will if you're in a different court with a different judge.
Thank you for that. The next question is, can I apply for asylum and DED together at the same time?
You cannot apply for DED. You're either covered by it or you're not.
If I may add also, if you are Palestinian and you're applying for asylum, I would strongly encourage that you argue you are stateless as well, because that in and of itself is a relevant factor that could really support your case.
So how does someone know if they are covered by DED?
That's a good question. And so hopefully community forums like ours and our website that we have up are sharing positive and informative information in the sense of, how do you know? Well, we know that the date in which it was announced was February 14th of 2024. And it says very specifically that you had to have been physically present in the United States on that date. So I think that's the first element that has to be met. Were you physically present in the United States on February 14th? If you meet that criteria, then you work backward through the other requirements that are laid out in the memorandum, followed by what is coming or what we're expecting with the federal registrar. That would be the best way to determine whether or not you qualify for that issue. And again, as Lena identified, that there are things that make you disqualified. And this is where, again, it's very important that you are working with an immigration attorney who can go through your immigration history, go through your criminal contact in the United States, because some of the areas that do make you ineligible are certain criminal acts, certain misdemeanors, certain felonies. And so again, if you are applying for a benefit with a work permit and it requires biometrics, which means they're going to take your fingerprints, they're going to check your background. If you have these other disqualifying factors, you've now notified Department of Homeland Security of where you are, what you've done, and you now become an interest to them. So again, proceed with caution with any application you file before an immigration office, and again, work with somebody who can assess your situation appropriately.
Thank you for that. The next question asks about someone who arrives to the U.S. at the airport. Can they apply for asylum at the airport if their visa is denied at the airport?
I can answer that. The answer is yes. If you arrive at the airport and you're told that you're not going to be allowed in, if you indicate that you have a fear of returning to your home country, then the airport officer cannot deport you. What will likely happen is you'll get taken into custody and you'll be scheduled for what's called a credible fear interview, where you meet with an asylum officer and briefly explain to them the reasons why you're scared to go back to your home country and describe any persecution you've suffered in the past. And they will also go over the eligibility requirements for asylum. If they find that you've established a credible fear, meaning that they believe that you have some kind of fear and that you meet the general requirements, they will refer your case to an immigration judge where you can present your case. Most times, not always, people who are going through the credible fear process will stay in custody throughout the entire immigration case. So keep that in mind. But you can also ask for parole, which is basically a request to immigration to release you while your case is pending. And if you're found not to have a credible fear, meaning the asylum officer does not think that you have a basis to apply for asylum, you can ask for review with an immigration judge. And the immigration judge will just review whether or not they think you actually have a fear or not. This is the same process that happens at the southern border with Mexico.
Okay, that's very good to know. The next question we have is from someone who is here on an F1 visa. So they're students from Palestine with a Palestinian passport, and they're asking whether or not they should file for asylum or continue on with OPT after their F1 status ends. Any ideas?
It's a pretty loaded question to answer in a forum like this. Filing for asylum obviously is something you should do if you are afraid to return to your country. But before doing so, again, I would recommend speaking to an immigration attorney and seeing if that's your best course of options, a best course for you, as opposed to maintaining on your F1. So consult with an attorney is my best advice.
And it would seem as though, and I have to just full disclosure that I don't handle a significant amount of F1s using the OPT program, but it would seem as though you can have those at a concurrent state. So you can maintain your F1, you should be able to continue to apply for your OPT and still apply for asylum. Again, making sure that all of those issues are evaluated appropriately, but I don't think you are exchanging one for the other. And as I like to say, I have many individuals who are here in U visa status. If something else becomes available, right, we always consider it. And because some of these other benefits take so many years to get resolved, that it is possible you could have one or two things in the pot trying to get resolution. So I think that that is accurate as well with the F1 program and OPT. And if somebody else wants to speak to that, but I would say definitely speak with an attorney, but I don't think you're having to choose one over the other. I believe it's a layered program.
So the takeaway is speak to an attorney, but you may be eligible for more than one immigration benefit at any given time. So you can have OPT and asylum at the same time. They don't affect each other. But always ask an attorney, always get legal advice on your specific case. Again, this is just being provided for general informational purposes. Another question, if I am applying for asylum and I already have a work permit through my asylum case, should I apply for another one through DED?
I can answer this question. Of course, at first you'd have to determine the validity date of your work permit and how long it is valid for. Currently, asylum applicants are receiving work permits that are valid up to 5 years. The DED program is an 18-month program. And something we did not mention or haven't heard yet is it could be revoked or rescinded by the president. This president could revoke or rescind it, or a future president can revoke or rescind it by the time we hit that 18-month mark. So if you do have an active asylum case and you're able to renew your work permit on that basis, my advice would be to stick with that work permit since it's going to give you a longer duration and is tied to your foundation case, which is the asylum case. If anyone else has anything to add, please do so.
I agree, especially the work permits based on asylum are now issued for 5 years.
Wouldn't there be some argument to be had as well? And I think maybe this came up as far as expediting some of these asylum applications at this point due to the extreme nature of what is happening in Gaza and that Palestinians are being subjected to at this point. I'm just curious of those who are practicing more asylum law, if that would be advantageous. And again, always working with your immigration counsel, but to push on some of these applications at this point.
I would say sure, but my experience here in San Francisco is it's basically impossible to expedite. So if you want to try, sure, but I'm not hopeful that even for Palestinians, asylum applications will be expedited.
Yeah, I'm here in Los Angeles, and I would say that it's extremely difficult to get a case expedited as well, but it doesn't hurt to try. I mean, the worst they can say is, no, sorry, you have to wait. So why not try? If it's free to try. It's an email for us over here with some, a statement explaining the circumstances. And then I would also add, if you haven't considered a stateless designation or a statelessness argument in your asylum case, please do so, especially, of course, if you're Palestinian, it's very important.
And lastly, before we wrap up, for those of you who can afford it, an option to get your asylum case heard if you're experiencing delays is called a mandamus, which is essentially a lawsuit against the government for the unreasonable delays in processing your asylum case. So if you are a Palestinian and you've been thinking about doing this mandamus action, now might be your time to really proceed with that. Again, consult with an attorney. It is a lawsuit against the government, but we have seen that people who file mandamuses are getting their interviews after filing this mandamus action. So if that's something within your means and consulting with an immigration attorney and you decide that's your best path, that could be one good way to get the interview if the request to expedite does not work.
Great, thank you for that. A couple of questions more. What is the Federal Registry or Register?
It's basically a daily publication by the US government, which announces rules, proposed rules, issues notices. So for purposes of DED, it's going to basically be a detailed announcement explaining the president's announcement of DED. So it'll have where to file, what, who can qualify, whether advanced parole, travel permission will be allowed. So it'll basically be a detailed breakdown of DED for Palestinians.
And I think accessing that, again, once USCIS, it kind of is in coordination with one another. So once USCIS has the Federal Registrar's publication of this information, USCIS will post it on their website connected to DED for Palestinians. And again, in there will be a link that you can actually read the Federal Registrar, but most of that information will be as well conveyed on USCIS. So if you're like, where do I find the Federal Register? Again, I would sort of pause until USCIS has this information up. And from there, if you really wanted to be more thorough about it, you could click on the link or the citation within that website.
Okay, and the last question we have is, I just came to the US 2 weeks ago on a tourist visa. Can I apply for DED?
Let me end with this. You do not need to apply for DED. You are automatically protected. If you are Palestinian, have been in the United States before February 14th, and you meet the other criteria, you automatically qualify. No application is needed. And if there are people out there trying to tell you to pay them for them to apply for DED, do not fall for that. The only application you need to file is an work permit application, an EAD. You do not need to file for a DED protection.
Thank you for that, Hassan. Thank you, Lena. Thank you, Van. Thank you, Amanda. Thank you, Noor and Tariq, for translating. Those are all of our questions. And I'll open it up to the panelists if you wanted to add any other last points. We don't have any more questions that we need to address for this community forum, but I will give you guys a few minutes if you had any last thoughts.
Maria, there was one question that just popped up in the chat as far as how can we access this recording. Can you share where this will be posted and where individuals can come back and re-listen or share if necessary?
Yes, thank you for that, Mandy. So we will be posting this community forum on our website. It's bit.ly/projectijp. I just put that in the text in the chat for everyone. And if you just Googled Project Immigration Justice for Palestinians or the Arab Resource and Organizing Center, that will pop up. And so we will be able to post that on YouTube with a direct link from our website. So thank you all for joining us tonight. I hope you found this information very useful and beneficial. If you do have any follow-up questions, we are providing free consultations as part of Project IJP for anyone who does need help accessing all of these immigration services and benefits that are available. Again, nothing has been issued on the Federal Register or through USCIS. And like our panelists mentioned, it may be too early to apply for a work permit, but go ahead and sign up, fill out one of our Google forms if you do need assistance or would like to talk to an attorney. Thank you again for all the panelists, all of the time that you put into this and the effort. I hope that we'll have another opportunity to talk after DED has been published in the Federal Register, and if there are any additional updates. Thank you again for joining us tonight, and I hope you have a great night.